This is an appeal in the matter of F4 and the Secretary of State for the Home Department.
Yes, good morning, Mr. Squires.
Well, Lord Lady, I represent the appellant with Ms Mitchell and Mr Blundell KC and Ms Parson represent the Secretary of State.
Yes. We've read, thank you very much for the we've read, I think, the key, we're up to speed with the issues, I think. Have you had a chance to talk to Mr Blundell about how long you think you're going to be and how long we're going to be all together?
We haven't. I suspect I'll be this morning.
Yes, it seemed to us that the issues were fairly clearly reversed. We wondered whether we were going to take the whole day. But let's see how.
Yes, if I can speed up, I certainly will. I was going to start with a preliminary submission on the general approach that we say it's appropriate for this court to take to the appeal, and in particular, what happens if the court has any doubts as to whether SIAC correctly applied the law, asked itself correct questions, properly took into account all relevant considerations in the correct way. And it concerns the application of the anxious scrutiny standard. As the court will be aware, the anxious scrutiny standard applies if a court's dealing with a decision of fundamental importance to an individual. And here we say it's difficult to exaggerate the importance of this appeal for the appellant and her son. If the appeal is refused, the consequences are that she has no prospect of getting her British citizenship back, and that of course affects fundamental rights to live in or return to and live in the UK. And those rights are of course important in the abstract, but in this case, the appeal has much higher stakes for the appellant and her son than that, because if she loses the appeal, the consequence will be that she'll technically be a citizen of Somalia, but that's the country that her family fled before her birth. And if she loses the appeal, it's very likely she'll never be able to return to the UK, which means she either remains in what we'll see as the appalling conditions of Camp Rog, or if she is ever able to leave, going to a country where she's never lived, doesn't speak the language in which I say her parents left as refugees. And the consequences for her son are equally dire. He'll suffer the same fate as her, or be separated from her. He's a British citizen. He's age 8 and he's a British citizen. So he would be able to return, but that would be on his own, leaving the only caregiver he's ever known. Otherwise, if he remains with her, his fate is the same as hers. She doesn't speak it well, I think, is the... She speaks language poorly, I apologise, yes. She speaks it poorly. She does. My lady's right, there's some significance to when she was communicating in English and when in Somali.
Your point is that she's got very tenuous links.
Yeah. So the consequences for her of failing in this appeal are of the utmost seriousness. By contrast, if she succeeded in the appeal and was able to get her British citizenship back, her and her son's life would have an entirely different trajectory. And I don't make those submissions in an attempt to elicit the court's sympathy for the appellant and for her son. If she's out of time and there's no basis for extending time, that is the consequence of having time limits, whatever the consequences for her. She's unable to appeal. But we do say the consequence of what's at stake for the appellant, or the consequences for her do have legal. There are legal matters that flow from that. And of course, they were relevant to my lady's grant of permission to appeal. My lady observed that was one of the bases for granting permission to appeal was the compelling reasons relating to her, or the consequence for her if she lost her right to appeal. But we say the consequence also applies to this court, and that we say comes from the anxious scrutiny standard, which we say applies. And I know this will be, I'm sure, very familiar to the court, but I wonder if I could ask you to turn up YH, which is Lord Justice Carnworth, as he then was, explaining what the anxious scrutiny standard is, because as he says there, very often it's used as a mantra, but but it may be important just to look at what he says it means and when it applies. It's tab 3 of the authorities bundle, page 29 if you, of course you're always in paper bundles, yes, so it's tab 3, and it's paragraph 22 to 24. This is about what amounts to a fresh claim in a human rights and asylum context, and it's paragraphs 22 to 24. And I say this may well.
To read that?
Yes, yes.
You sit down. Thank you.
And 3 observations on the passage. You'll see from the quote from Lord Justice Buxton at the top of page 37 on the internal numbering, that it's where anxious scrutiny applies, it applies to all relevant decision makers, Secretary of State, adjudicator, the court. And it applies particularly where the consequence of an incorrect decision will have important ramifications for the appellant. And as Lord Justice Conworth noticed, often the phrase is often used, but what does it mean? And it means, it's this passage between C and D, page 37. It has by its use acquired special significance as underlined the very special human context in which such cases are brought, the need for decision to show by their reason that every fact which might tell in favour of an applicant has been properly taken into account. And so how that applies here, we say clearly an anxious scrutiny context given what's at stake. And what that means is that if when the court comes to it, it has some doubt about whether SIAC has applied the law correctly, has some doubt about whether it properly asked itself and determined what was the explanation for the delay, some doubt about whether it rejected the appellant's explanation because they were considered objectively unreasonable, which we say is incorrect, then we say the outcome should be to allow the appeal so that SIAC can then reconsider the matter.
So the way you seek to apply this is in the application of the law?
Correct, my lord, yes.
Not doubt about what the law is?
Correct, yes.
That would be a nice truth, because it began to sound a moment ago as if you were saying the latter.
No, it's the application. If it is not clear whether SIAC has applied the law correctly, of course the law will be decided one way or the other, but if it's not clear whether it applied the law correctly, the answer we say, because of the different consequences of an incorrect decision one way and the other, mean, in our respective submission, the appeal should be allowed. Yes, correct, my lord, yes.
Can I be right, Mr. Clark? The normal position on appealing a form of law from a specialist court for time being is that unless there's an express misdirection, people can be sure that they got it wrong, you assume that they've got it right.
You may assume they've got the law right, but whether they've applied it correctly. It may be when I come to, because there are some parts of the judgment which we read in our favour, but if that's wrong, they're at very least ambiguous as to whether the law was applied correctly. I'll come to that if I may.
That can be described as a straightforward reasons challenge. The reasoning is so ambiguous that you can possibly conceive as an error of law.
Yes, it might, my lord. As I say, we'll see when we get to this will probably make more sense when I get to into the submissions. Turning next to the legal framework, we set that in our skeleton 29 to 34. It's Rule 8 of the SIAC rules that governs time limits, and the time limit here is 28 days. Because the appellant was out of the country, there was service of notice to file, which I'll just make a may recall from the D4 case was the issue there. The law was then changed to retrospectively deem.
Before the case can be considered by the Supreme Court.
Yes.
See whether the last clause is minority statement is correct.
Yes.
We'll never know.
We will never know. Retrospectively deemed service 28 days runs from the 20th of December 2019, and of course she doesn't appeal for 2.5 years until August 2022. Therefore, she needs extension of time under Rule 8.5, which I'm sure will be familiar to the court, or will be now. Commission may extend the time limits in this rule if satisfied that by reason of special circumstances it would be unjust not to do so. And the court will have seen that both below and here, the parties agree that the principles are set out accurately in C12. And you have...
C12 ever been approved in this court?
I don't know that it has. If I don't know this...
There's no challenge to what the court said, what said in C12, is there? Is that accepted by both of you?
Yes, I'm going to make some points perhaps to sort of draw something out of C12, but I think both parties accept and accepted for SIAC that that's
is it applied as a matter of course in these cases?
I think it is. I think it's safe to say it is. Yes, it's relatively recent, but
you
it's...
would say it was no harm for this court to review it.
Yeah. I think both. I wanted to make, though, I say, 5 observations about what's said in C12. I don't know if the court has it in front of the 4 paragraphs in front of you. You have it in our skeleton at 30, or it's in the appeal bundle tab 7, page 97. Again, it may be helpful just to glance over it if the court hasn't. Well, just to go to those wherever you find it. It's set out in our skeleton. Paragraph 30. It's paragraph 19 from C12. So we make 5 observations about what's said. First is that proving special circumstance doesn't mean establishing the case is unusual or rare or the reasons for the delay are somehow exceptional. It just means... Yes, it did.
Special does not mean exceptional.
Does not mean exceptional. It just means why on the facts of this specific case the normal time limit shouldn't apply. So it's not enough, obviously, if the appellant say it is unjust that I have to appeal within 28 days. That is the time limit. There has to be something particular about their case as to why it would be unjust. But that is all that special circumstances mean. Second, SIAC held correctly, paragraph 9, that the ultimate test is whether it's unjust not to extend time, but went on to say that that's a high hurdle. And we, with respect, say it's not clear where that gloss comes from. Something's either unjust or it isn't. It's a normative judgment for the court, or here SIAC. There's no requirement for it to be manifestly unjust or language of that sort. Third point, on the burden and standard of proof, and this will be important in this case, it's that the burden is on the appellant to demonstrate special circumstances, and that's by way of evidence as opposed to submissions. As we'll see, the Secretary of State mischaracterised our case. We'll come to this under ground 1 as suggesting the appellant is entitled to submit no explanation and no evidence, and then it's for SIAC. If SIAC then doesn't itself come up with an explanation, that's an error. That's, of course, not our case. We've always accepted it's for the appellant to provide an explanation, and that is an explanation that has to be supported by evidence. Fourth point, C12 19.2 says that the starting point is to establish the explanation for the entire period of the delay. And we say that is critical. And the reason for that, we say, is obvious, because the explanation for the delay is very often dispositive, one way or another. if there's no explanation, or we refer there in our skeleton to H2, if the explanation is the individual is indifferent, unconcerned about the decision, it is very unlikely that time will be extended. Conversely, if there is a compelling explanation, it is much more likely it will be unjust not to extend time. Fifth, once the reasons for the delay are established, SIAC has decided X was the reason or no reason has been established by the appellant, SIAC then moves on to consider all relevant factors and balances them out. Now, one might read C12, and this is just the gloss I put on it, as suggesting that these are two separate stages, because the way it's written in C12, and this is also, SIAC here said the same thing, 19.3, starting point explanation, once the explanation has been established, other factors are to be balanced. And we don't think SIAC means is you've got the explanation, you put that to one side. Of course, the explanation is likely to be one of the key factors that you're balancing along with others. So you will look at other factors such as prejudice to the appellant or impact on the appellant if the appeal doesn't go ahead, prejudice to the respondent, merits of the appeal. But those are all balanced with, in some cases balanced against, how good an explanation there is for the delay. And as I say, that is very likely to be, and certainly in the 3 SIAC cases you've got in the bundle, it's dispositive, determinative in each one of them. In the cases where SIAC was not able to find an explanation for the delay, or none was put forward in C12 itself.
Can we go back to, if we could, to your fourth
The starting point,
yeah.
yes.
And what do you understand the word satisfactory to mean? 92.
We understand that to mean how compelling is the reason for the delay. So a satisfactory. So if I'll give an example in H2, for instance, this is a case where what happens is that the individual citizenship's removed. SIAC finds he's indifferent, unconcerned about it. What then happens is he appears that he's then arrested in Djibouti, and his British citizenship obviously becomes much more important, and he appeals. So that be an example where there is an explanation. In a sense, it's not a no explanation case. SIAC has got an explanation, but it's not a satisfactory one. So that's how I've understood it. It's a judgment of essentially how compelling the explanation is. And that's a contrast with a no explanation case. And in fact, C12 itself, he says, I didn't know my citizenship had been taken from me until 7 years later. SIAC finds a matter of fact that he did. It then says, well, you're then in a position where you've got no explanation. And what one finds when one looks, so I won't take you through them, but you have 3 SIAC cases here, C12, C11 and H2, and all of them, we say, correctly follow essentially the same structure, which is recognise the burden is on the appellant to establish special circumstances, see what the appellant's reasons are for the delay, see if they've been established. Once you've got the explanation or decided there simply isn't one here, you then move on and conduct the balancing exercise. Can I move on next? My third topic was the factual background, which I'll do briefly.
Yes, I think you're fairly clear about that, but do say what you...
Yeah, I would be. What I just wanted to draw out, I think, from the facts is what we say is the striking central feature of the case and central to the appeal, which is why doesn't the appellant appeal here for two and a half years, despite on SIAC's finding her repeatedly telling her family she wants to come home. On SIAC's finding, she understands what she needs to do in order to appeal the deprivation decision. It's been explained on SIAC's finding very clearly to her in January 2020. Why doesn't she appeal for 2.5 years? and does SIAC grapple with that question correctly? So very briefly, and I'll do this by headline points because and give the court the references, because we'll see how this comes up when we turn to the explanation that's put forward. In terms of circumstances prior to the deprivation, you will have seen, and this is, or the reference is Professor Patel's report, paragraph 6 to 11, that the appellant has, on any analysis, an extremely difficult, very early childhood. So she's born in a refugee camp in Ethiopia. Her mother leaves after 16 days, and she's not reunited with her until she's 3. Again, we'll see where this is picked up in Professor Patel's evidence. You then have, age 17, she travels to Syria, so she's still a child at the time. And it may help just to, probably the easiest way to do this is just to see what Ms. Foer says about this. I'm going to show you the 2 paragraphs in her witness statements. This wasn't disputed. It's a supplementary bundle, page 129. 129. 12 to 13. We'll come on to that when what Professor Patel says about trauma, but it seems fairly clear that the appellant was a victim of trafficking. She goes when she's 17, taken, it seems, to Syria, certainly accompanied, recruited, compelled to marry an adult man. You see then the abuse that she then suffered over the next 4 years. She then arrives in Camp Al Hol in April 2019. And again, you'll see, just glancing down, you'll see 14 to 17 in Ms. Foer's witness statement. The circumstances of her, you see 16 fleeing. She flees, finally successfully flees ISIS-controlled territory, an abusive husband. She has a second child who dies early in 2019, 3 months old. And you will also see it's paragraph 18 in his first statement. It's also paragraph 12 in our skeleton. Again, I won't take you the truly appalling conditions that there are in camp. Al Roj, I know my lady will be familiar with this, having made the finding in the first Shamima Begum SIAC case that the conditions would constitute inhuman and degrading conditions. And you'll see paragraph 12 sets out what those conditions are. And they were particularly difficult for this appellant. And you have a report, again, I won't take you to it, but it's from a Dr. Cohen, who, and this is in December 2019, so very shortly before the deprivation decision, who sent a photo of the appellant, which is one you have in the supplementary bundle at 201. And she concludes, having seen another photo, having been told her symptoms, that she was severely malnourished, suffering from rectal bleeding. Her and her son had persistent diarrhea. Her son also was likely to be suffering from malnutrition. Described her as too weak to walk, struggling to access food or medical care for herself and her son. That's in Dr. Cohen's report. Could you have the supplementary bundle at 176? So those are the circumstances in which the deprivation decision, or her and her son's circumstances, when the deprivation decision is taken. The deprivation decision taken on the 20th of December communicated SIAC fines, as the court will be aware, at some point between the 24th of September 2019 and the 5th of January 2020. And you have in SIAC's judgment, I won't take you through it, SIAC sets out the factual chronology of the different voice notes. It's all communicated by voice note. So it's paragraph 17 is F4's mother sends her a voice note that says, I sent you a voice note previously, please listen to it. I want to tell you your citizenship has now been revoked last Friday. That's referring to an earlier voice note that we don't have. She replies 6th of January, this is SIAC paragraph 18, please leave the appeal hearing with the visa ID. This is in Somali, and that, we're told, can encompass citizenship. I told you, Mum, but maybe you did not understand me in the first voice note. If you have SIAC's judgment, you'll see paragraph 19, mother sends another voice note in Somali telling her we can appeal the decision. You have to apply for the appeal and express that you want to appeal the decision. There is a letter written by a human rights lawyer that is working for us, which I'll show you in a moment. Use this letter as an example, etc. If you want to appeal. Paragraph 19, you'll see, if you have SIAC's judgment, you'll see her response. Mother, I'm not angry with you, but I want to say this quickly. Please leave the idea of appealing the ID visa. I told you, Mum, but maybe you do not understand me, etc. Now, the letter that F4's mother is referring to is a letter sent by Reprieve.
Not the one on the 9th of January.
Yes, it's 9th of January. It's sent to F4's cousin.
That would be after these dates.
That is, and that was my next, where I'm turning to next to the chronology. I think what it looks like, maybe there is another letter. Yes, there's a letter. Yes, a good point, my lord. Yes, I'd assume that was the same one. But yes, I think that letter is. Well, it's sent to the cousin, I think, on the 9th. Whether it was sent earlier, but it's an important letter.
Sorry, are you going to refer to this other letter that seems to have been sent before the 9th?
I'm not, because I wasn't sure whether I'd assumed it was the same one. But the letter we have is the one that's sent to her cousin on the 9th, and then sent on to her, and we'll see. SIAC finds that she has read it in full, which is important to SIAC's decision. And I think it would help to turn it up if the court hasn't had a chance to look at it. It's 164, 163 of the supplementary bundle. And it's discussed in detail in SIAC's judgment at 2027. It's probably easiest just to look at the letter itself. So if the court has it, it's addressed to her. The person introduced themselves. Second paragraph, I've been working with your mother and your cousin to try to get you and your son back, brought safely back home to the UK. Explains that her nationality has been taken away.
Is this letter dated?
I don't.
Is this the letter that's referred to in the voice note of the 5th of January? Because it's written by, I assume, the author. Is the author's name confidential?
No. No, I don't think it is.
This
Date on the letter.
No.
Elisabeth is a human rights lawyer working with them.
Yes.
So is it?
So what we don't know, and I can try and we can.
We don't know where the site got the date of the 9th of January.
Yes, we do. I think that's in Ms. Foa's evidence. I think she says. So I guess I'm pretty sure Ms. Foa says it's the 9th. It went to the cousin and then went on to her. We can get the reference.
I mean, I was looking at how the letter is described. Looking at how the letter is described in the voice note of the 5th of January, question paragraph 9 of site. Sorry, paragraph 9 of site. And that was pretty much like a summary of what
Yes.
Elisabeth was doing.
No. I think what we've got, Ms. Foa's statement, supplementary bundle 147, paragraph 49 confirms the 9th of January is the date it was sent to the appellant.
Yeah.
It may well have been sent beforehand to her mother and it's then sent on. But certainly I don't think there is no other suggestion of another letter. I think it's this.
It's pretty clear.
It did, absolutely. And you'll see, and we'll come back to it. No, we agree. If we had to hazard a guess, we think we're fairly confident this is the letter. And it certainly does go to her on the 9th of January. That's as far as evidence. As if you have it, the third paragraph, decisions taken made to take your nationality away from you. We're working closely with 2 human rights lawyers at Bernberg's. They would like to try and help you challenge these decisions so you and your son can come safely back. I know your mum has always asked you whether you wanted to appeal the decision, how it's a big decision, how we could help you to come home, says the things they could do. It also explains, going back towards the bottom of the page, penultimate paragraph, if you want us to, we want to try to make sure the government help both you and your son come back together by asking the court to order them to do this. Very experienced, lawyers with lots of experience. Then in bold, they would not ask you or your family for any money for their work. Over the page, explains an appeal. Again, this is the SIAC. Again, in bold, we would ask the court to keep your and your son's identity secret to protect you. Then reprieves you, we think you should do this, I appeal, because it will be very hard for you ever to come home to the UK or even to visit if you do not try to keep your British nationality. So absolutely clear what is being said to her there. Assuming she understands it, it's written very clearly. What should you do if you want to come home with your son? Under there, if you still want to come back to the UK, challenge the government decision. Again, in bold, you wouldn't have to pay. We'd ask the court to keep your name and identity secret. And then the deadline. So it tells her 20th of January, very soon. If you do not challenge the decision to take away your British citizenship now, it'll be much, much harder for you to come back home with your son. In bold, if you think there is any chance you would want to come back to the UK with your son or to continue to be a British citizen, I would suggest that you appeal the decision now. It'll be very, very hard, maybe impossible to do this later. And then next steps, it's then made incredibly easy for her what she has to do over the page in bold. Please can you write these words on a piece of paper, sign and take a photo, and that's
well,
it.
That's where I think it's the letter that's referred to in the earlier voice note, because that wasn't summarised clearly.
Yeah. Yeah, I think that's probably right. What it looks like, the mother must have seen it first. It's then sent to her, to the daughter, to the appellant a couple of days later. So she gets it on the 9th of January.
I mean, this is, if I may say so, a very clear letter.
Yeah.
No doubt drawing on her experience from the English field. What's the fact?
No,
and needed to be spelled out.
And we say, and we'll say, I'll come on to this. It's critical to our appeal, as we'll see in a moment. But what SIAC said about it, and this is the error we say SIAC made, is SIAC describes this letter very much in my Lord's terms as a model of clarity and simplicity. It explains why appealing deprivation decision was highly important if Ethel wished to return to the UK with her son. No. That is, as a description letter, we say absolutely right. What SIAC also found, as a matter of fact, that the appellant had read the letter in its totality, paragraph 59.
Well, that is based on what she said in the later voice.
That is what she said in the later voice, precisely.
No,
the finding. I'll come back to that when I get to our grounds, to the extent to which we challenge. We don't.
In the later voice note, she refers to the letter. You were shaking your head.
Well, what she says in the later voice note, she says, "Mother, I don't want to complain.
She refers to it.
Please tell those who sent the letter I don't want it." Yes, oh sorry, she don't. Yeah.
I mean,
Yeah.
use the word referred to.
Yes, my lord, I apologise. No, I was thinking of a different bit of it. No, my lord is absolutely right. So she refers to that, and SIAC also points out that she says, "I don't want the British citizenship," and it says it's significant she used that word because that's the word in the letter. So that's the position, and I'll explain what we challenge and what we don't when I get to my grounds. As I've submitted earlier, the starting point, C12, C11, H2, is what's the explanation for her not? Why doesn't she appeal after, on SIAC's findings, she sees this letter? And we certainly don't challenge the fact that she's SIAC's finding that she reads the letter in its totality. That's a finding of fact that SIAC make. We certainly don't say that's an irrational decision that she read it in its totality. We have some other concerns about it, which I will come on to. Also, perhaps I shouldn't. Can I scrub that concession? I'll come to it. It's slightly more complicated than that, but that's the finding that SIAC makes, and we certainly don't challenge it for our first two grounds, which I'll come to. In terms of looking for the explanation, what we know is not an explanation is that she's indifferent to coming home, is done with the UK, doesn't want to return there with her son. To the contrary, SIAC's findings, and it's important to SIAC's decision, that throughout this period, in fact throughout the entire 2.5 years, she very much wants to come back to the UK. And it's entirely unsurprising when one thinks about the conditions in the camp. And we see that from SIAC's decision. What's in paragraph 13, paragraph refers to her mother signing a next friend authorisation enabling Reprieve to take steps to assist her. And Reprieve then send a letter to Dominic Raab, then Foreign Secretary. And SIAC notes that it's on behalf of F4 and her child and asked him to facilitate their return to the UK as a matter of urgency. And if you have the letter, and you can see why SIAC concludes that it's written on behalf of F4 and her child. The letter's at 168. It's listened to the Foreign Secretary. We write on behalf of the above name, so that's the appellant, a young British mother currently being detained without charge. Her son is then 3 years old. And you see at the end of the paragraph, we've been in touch with the mother and her cousin, who have been in touch with the appellant and confirmed that she wishes to receive consciousness, including in relation to repatriation to the UK. They go through the conditions in the camp. And then page 170, you see the underlined section, as set out above. The appellant and her son are requesting consciousness to facilitate their return to the UK as a matter of urgency. And Reprieve then also sends a briefing note to ministers, which you have a little bit further on, which is a more detailed document. It starts on page 198. This is sent further to the original letter, I think it's referred to in that letter, 198. Briefing to ministers, the appellant, there's a picture of her son, there's then the picture of her over the page. It's the one she was sent to the doctor, unable to stand or walk unaided. And then, very end of 202, you'll see F4 is extremely concerned about the well-being of her child, is particularly fearful of what would happen to her son if her conditions worsens while in the camp and he is forced to fend for himself. Since arriving in the camp, and then this is important, the appellant has used every opportunity to express to her family her desire to return to the UK and give her son a chance at a stable life. The request for repatriation is refused, and Bernburg Pierce write a letter before Clane on the 24th of January 2020. I don't think we have the letter in the bundle, but what SIAC says about it is that it reiterates the appellant's desire to return to the UK with her son. That's paragraph 65 of SIAC. So that's still in, and SIAC finds certainly that continues to reflect her desire, the desire expressed. We see expressed earlier, she's said to her family, used every opportunity to express to her family her desire to return to the UK.
Is that reflected in the voice notes?
I don't think it is. I don't think it is by law. No, SIAC, fine, we'll see when we get to SIAC's reasoning. For SIAC, it's a point of real importance in their conclusion that she, at all these stages, is expressing this desire to come back to the UK. We say what it does. It strongly suggests that it strongly suggests what the explanation is likely to be for her failure to appeal. That you get this, because what you get, or the position one has, someone who is, quotes, extremely concerned about the well-being of their child, used every opportunity to express to her family that she wants to return to the UK, seeks her family's help, and they act via reprieve and via lawyers, all of which express this desire to return. During this time, her citizenship removed, and reprieve sent the letter, which I say we agree, as my lord said, is a model of clarity and simplicity. SIAC finds she's read it in its totality, and it tells her in absolutely clear terms, if you think there's any chance you would want to come back to the UK with your son, I would suggest you appeal the decision now. It'll be very, very hard not to do so later. And if she doesn't appeal, she is told, quote, it will be very hard for you ever to come home, even to visit. But then she doesn't appeal for 2.5 years, and the obvious question is why? And I'll come to that, so how SIAC does, or we say does not, deal with that question. What you then have is effectively nothing happens further, whatever her basis for acting or the reason she acted as she did in January 2020 continues. She hasn't been able to meet anyone for reprieve at that time, but is able to in July 2021.
Yes.
And the court will know there's 2 meetings in July 2021. If they last, that the details of this are set out in the appellant skeleton below. If you'll note, it's paragraph 78, page 97 of the supplementary bundle, sets out the 2 meetings in July, I think last an hour and a half, 2 then in December, lasting about an hour, and then 4 in fairly quick succession in June. So it's the 15th, 17th, 18th and 21st of June.
22.
22, yes. Yeah. And it was after those repeated meetings, and we'll come back to the significance of that, why it matters that she was able to meet them so many times over a short period of time. The third of those meetings, so the 18th of June, she indicates that she wants to appeal. Now, during those meetings, she gives as her how she explains her not appealing, because at the outset, July 2021, issue of appealing must arise, and she repeatedly says, the reason we'll come to the evidence of this, that there's a concern that she'll be forcibly separated from her son if she appeals. We'll see where that comes from. And it's only, I say, in June 2022, and we'll see as far as evidence that she feels she's able to dispel some of the concerns and also to build up trust with the appellant when she says, okay, I'll appeal. And again, the striking thing is that throughout this time as well, SIAC's finding is she wants to come back to the UK. And you'll see that SIAC places considerable weight on the fact that she gave reprieve authorisation at the first of those meetings, 10th of July 2021, to assist her with welfare and repatriation related services. So again, for SIAC, we'll see why that's important to SIAC. It finds she is taking these steps, they're authorising them, because she still wants to come home. But again, despite having told she needs to appeal, despite it being made incredibly easy for her, she is unable, or for whatever reasons, we'll come to the reasons in a moment, she does not authorise the appeal. Can I turn then to our grounds of appeal? And you'll have seen there's 3 grounds of appeal. They rest on 4 propositions, factual and legal. First proposition is a legal one, which is that in determining whether to exercise its discretion in Rule 8.5 of the SIAC rules, SIAC is required to establish, as a starting point, the explanation for the delay in issuing the claims. And what that means, given that the way the burden and standard of proof operate for Rule 8.5 is this: the appellant has to put forward an explanation supported by evidence which explains the delay. SIAC must then determine on the balance of probabilities whether it's made out. It has to decide in the light of the evidence what is the explanation for the delay, or it can find no explanation has been put forward or established.
What is it about probabilities?
That's what it says in C12, and I think we all agree. I think it's because it's for us to establish, and it's a civil. I think that must refer to the factual matters rather than injustice. It's hard to see how one could establish injustice on the balance probabilities, but the facts, balance probabilities, I think is accepted. Once SIAC's established the explanation for the delay, or finds there's no explanation, he must then decide.
Is this your first or first?
Yes, still my first proposition. This is still the law. It then decides, taking account of all relevant factors, whether to extend time. So that will include, as we've seen, the merits of the case, consequences for the appellant refusing an extension, prejudice to respondent, etc. But it will also include the explanation for the delay, often as the critical factor.
If there isn't.
If there is an explanation, yes, correct. And indeed, if there is no explanation, often that will be a critical, and often a critical factor if there simply isn't an explanation. Second proposition, that in this case, 3 explanations for the delay are put forward by the appellant and supported by her evidence. And as we'll see, to some extent, they have similar psychological explanations, but they're conceptually distinct, and they operate as alternatives or further and alternative explanations. And between them, they cover the entirety of the relevant period from when she finds out about the deprivation until she authorises the appeal. And I'll show the court where those explanations are made, given, and the evidence for them. But in brief, what the first explanation, which relates primarily to the period in January 2020, is that because of her mental state and potentially cognitive impairment, brain fog as it's sometimes described, she simply did not understand that her citizenship had been removed. Or at least she wasn't certain of what had happened or what it meant for her. And she did not understand she needed to appeal. Or at least understand that if she did not appeal, she might lose the opportunity to do so. That's the first explanation. We'll see the evidence is in Ms. Foer's first witness statement, paragraphs 36 to 42. And it comes from the account that the appellant gave her, Ms. Foer, in October 2022. And as we'll see, this is rejected as a matter of fact by SIAC. SIAC finds you did understand that your citizenship was removed and you did understand that you needed to appeal.
What's your submission about that?
Submission on that is our ground 3. So the error we say made there. Well, perhaps I will come into some, I will come into it very, very short, but that's the explanation, and I'll come back to our submission on it. Second explanation a further and alternative explanation applies again in January, but throughout the material time. And in fact, this one comes into much sharper focus once SIAC rejects the first explanation. And the explanation is that even if...
When you say throughout the material time, you mean from January through to...
Yes.
Two and a half years.
Yes. I'll explain what it is. And the explanation is that even if she understood her citizenship had been removed and she needs to appeal, she didn't have the psychological resources to act, to take action necessary to proceed with the appeal. And the reason we say this comes into such sharp focus from SIAC's findings or SIAC's rejection of the first explanation is that on SIAC's finding, you have someone who understands their citizenship has been removed, someone who is told on SIAC's findings in very clear terms exactly what they need to do and made very easy for them. They're told, you won't have to pay any money, we can apply for anonymity, all you need to do is to copy out this sentence. She understands all of that on SIAC's findings. She also is someone in this period, quote, using every opportunity to express to her family her desire to return to the UK, and yet she doesn't act.
When you say the psychological resources to take action, the action she would have to take would have been to authorise
Correct.
the people in London to act
Yes.
on her behalf.
Yes.
In accordance with that short sentence that's
Yes.
in the letter.
Yes. And the answer is, and the answer, we'll see this from the psychological evidence, I'll take a step back. What you then have is someone acting in a way that is incoherent, inconsistent, and obviously contrary to their own interests as they are expressing them. To both say, every opportunity, I really want to come home, my son told you have to appeal and doesn't do it. I say you have someone on SIAC's finding acting in a way that is obviously inconsistent, incoherent, and on one level irrationally. And the answer to that, and we'll see from the evidence, is that she is, and this is particularly Professor Patel's evidence, so this is someone who's frozen, overwhelmed, are the word she uses. What she does, she just wants to push the matter away. She keeps telling, you saw from the voice notes, tell her mother, just leave it. Essentially tell her mother, please don't bring this up anymore. And we'll see in psychological terms, Professor Patel describes that as avoidance. Just don't talk to me about it, just leave it, is the tone. And now why someone would act so obviously inconsistently, contrary to their own interest, requires a psychological explanation. And that is given by Professor Patel, and it's essentially twofold. It's partly the result of the multiple traumas she suffered, in part her very early childhood, but much more obviously what happened to her over the previous 6 years. Most likely trafficked as a child to Syria, 4 years in an obviously abusive, highly abusive relationship, losing a daughter aged 3 months old, injured in bombing, both her and her son suffering severe malnutrition. All of those traumas, we'll see Professor Patel refers to. And it's also, the second thing, as a result of the appalling condition she finds herself in the camp, in which all of her physical and psychological resources are taken up just in order to keep her and her son alive. So taking further action, even however minor it might seem from the outside, feels too much for it, just feels overwhelming. So even if she understands she needs to do it, she can't. And that's why you have the apparent contradiction of someone on SIAC's finding desperate to come home, somehow unable to take this step. So that's the second explanation, and I will come, my lord, to what we say is the errors in relation to each of the explanation. Third explanation, again, it's a further an alternative, as we'll see in a moment, is she has a fear, again, whether rationally or not, that if she brought proceeding against the government, challenging her citizenship deprivation, that could lead to her son being forcibly removed from her. it's a fear, we'll see, she articulated repeatedly to reprieve in her meetings with them in 2021 to 2022. But there is also evidence, we'll see, that it was something that had been in her mind in the earlier period, so in January, right from the outset, a concern. So the Lord's Maid, that's our second proposition. She puts forward 3 strands, which between them cover the entire relevant period. And then my third proposition, and this is, of course, the core of the appeal, is that the way SIAC dealt with each of those 3 explanations betrays errors of law. And in relation to the first one, to answer my Lord's point, is that SIAC's findings that in January 2020 she didn't understand. SIAC's findings she did understand. SIAC's rejection. So the first explanation is rejected. She says, I didn't understand, or at least I wasn't certain, didn't know I needed to appeal. SIAC rejects that. And the error there, we say, is the Mbanga-Jakto error. So it's the Court of Appeal decisions in Mbanga and Jakto, and that's our ground 3. So the error there, I'll come to it in a little more detail, but in summary, is that SIAC reached a view on the credibility of the appellant's account, as recounted by Ms. Foer, before turning to the relevant expert evidence. And it then examined the expert evidence, Professor Patel, to see if it would displace the view it had already reached. And that's, we'll see from Mbanga and Jakto, an error of law. What Mbanga and Jakto say is if you have expert evidence relevant to a lay witness's account, what you can't do is reach a view, even a provisional view, says Jakto, about the credibility of that account, and then say, well, let's see if the expert displaces that or assists. What you have to do is consider them both together. So that's the error we say in terms of rejecting that first explanation. Is our ground 3. The second explanation, you'll recall, is the frozen, overwhelmed, unable to act. And the error there is our ground 1, which is that SIAC doesn't determine at all whether that or any other explanation has been established for the failure to act. And the reason we say it, that becomes very stark on SIAC's own findings, because it makes a series of findings that she's understood, she needs to appeal, she very much wants to come home, and then doesn't ask, well, why doesn't she appeal? But in particular, she doesn't ask, has the explanation she has put forward unable to act? It's not just not unable to understand. You'll see that they're put in one and the other. The inability to act, it simply doesn't consider whether that and the evidence that supports it is made out. And we say that's an error of law. The starting point has to be, based on the evidence the appellant has put forward, has she established an explanation for the delay? Third explanation, you'll recall, is the fear of being separated, forcibly separated from her son if she appeals. And that is the error there, we say, is our ground 2, which is essentially that we say SIAC didn't reach a conclusion on whether that was established as a reason because it considered the fear that underpinned the explanation, even if genuine, would not have been reasonable. Also, on SIAC's analysis, it didn't need to consider whether that was a genuine explanation because it considered it wasn't capable of giving rise to an extension of time. Otherwise, there's no sense. It makes no sense that it stopped in the way it did when it just stopped and said, not reasonable. We say that is an error of law. That's our ground 2. We say.
So are you going to take these grounds in the order that you indicated? 3, 1, 2.
No, I'm going to take them 1, 2, 3. So just because they're that way in the skeleton.
So 1 relates to the second explanation.
Yes, I apologize. It does mean I'm slightly.
The third explanation, and 3 is the first explanation.
Correct, yes. If that gets kind of confusing, I can change, but that was the order I was intending. Yeah, I'm obliged.
So I have to keep that framework in mind.
Yeah, part of the reason for that, I will explain it, is because the first 2 explanations assume we're not challenging any of SIAC's factual findings. It assumes that SIAC is correct that she understood, etc., that she understood, etc. So it's easier to, if we assume all of that is correct.
So you mean the first 2 grounds?
The first 2 grounds, yes, sorry, yes, the first 2 grounds. So yeah, the first 2 grounds depend. We can assume SIAC's factual findings are correct. That's why we put the other ground. I hope it won't get confusing. I will make sure explanations and grounds are used correctly. 4th proposition was that these are all material errors if they've been made. We'll see, save for a very limited extent, which we'll come to, the Secretary of State doesn't suggest that if SIAC erred in law and made the errors identified, that could not possibly have led to a different outcome. Doesn't suggest if they erred in law, it was inevitable. SIAC would still have decided as it did. I was going to turn next to go through the propositions. The first proposition, my legal one, I don't think I need to say anything else about it. I don't think it's, as I understand it, disputed. The second explanation was, the second proposition was there are 3 explanations covering the entire period. What I want to do is just briefly show you how those explanations are put forward and the evidence for them. Very much just to flag up how and where they appear. So the first explanation is the did not understand that her citizenship had been removed, and that's in Ms. Foer's first witness statement, supplementary bundle 133, paragraphs 36 to 42. It may help just to flag that, to glance through that. It will then become clear how the 133 supplementary bundle,
Paragraph
36 to 42.
Would you like us to read this?
Yes, please.
Right. It begins at October 2022.
So that's the first explanation. Paragraph 37 recounts at some point, Campbell, she thought that maybe her citizenship had been taken from her, but she was not certain. She did not fully comprehend someone's citizenship could be taken from them. So that's essentially the first explanation. You see top of 30, beginning of 39, did not understand that if she did not appeal, she would lose the opportunity, etc. And that we'll see is the one that Syke rejects as a matter of fact, and I'll come on to that. So that's where you find the first explanation. Second explanation, and as I say, this arises considerably more starkly once you've rejected the first, because you've then got the obvious sets of contradictions, is the freezing, unable to act. And I can show you where that's set out in submissions, and then I'll show you the evidence. But briefly, I'll flag up the evidence. If you have F4's skeleton below, it's page 79. I won't take you through the yes, part, yes, supplementary bundle. I won't take you through the entirety of the skeleton. I'm just going to take you through how at least it's introduced in a couple of other submissions. If you have paragraph 3, she was informed, as said in early January 20, she was able to attend to or engage with the information provided, so unable to understand, still less the possibility of taking action based on it. So she just tells her family to leave it. And again, page 89, paragraph 49, this is the overview of the reasons for not appealing. The first, Professor Patel's evidence. And again, it's the engaging with the decision or the potential to act on it.
So that's covered in the first thing, all that is paragraph 30 and 39.
This goes significantly further, because, and we'll see where the evidence for this is. It's about why she doesn't have, it's the possibility of acting, even if she understands. What she doesn't have, it's being frozen. You may understand that your citizenship's been taken away, but you just feel overwhelmed, frozen, unable to act. And so it's and we'll see the evidence for that. This is just the submission. It's the possibility, what she's unable to do is the possibility of taking action, as distinct from not understanding. And you see it again, paragraph 74. How you understand her responses. She's both unable to engage with the information, but also it's the possibility of acting on it. And I say it's that latter, the possibility of action, that comes into such stark focus once you have Syke's find.
This is submission document.
Yes, this is
And this is drawn from, is it? I'm sorry to get back to this. Ms. Ferrer's statement and other materials.
yes, it's drawn from the evidence. I'll show you, but particularly it's Professor Patel's evidence.
Okay.
This is drawn from.
Well, the reference is presumably in paragraph 49.
Yes, Professor Patel. And we'll see that shortly. So no, the Musfoa, I should have made this clear. Musfoa is setting out in that bit I showed you just what the appellant had told her, and that is I wasn't certain. I didn't really understand what was going on. Yes.
Can I ask this? Are you going to make any submissions about what's said in paragraph 40 of this? let me spell it out.
Yeah.
To what extent does it feature in this case that an explanation given at some point to Miss Farr was the rumours that British detainees would be transferred to Iraq? Does that feature in any of this analysis?
I don't know that it was featured in the explanation put forward by the appellant as one of the reasons. It links to, I think, her general confusion as to what was happening, and the next paragraph refers to her fear of her child being taken away. But I don't know that it's ever been put forward as an explanation of why she didn't appeal.
Well, isn't it dealt with by SIAC at paragraph 63 of the decision?
Yes, I mean, oh, sorry, I may have missed. Yes, no. So SIAC, what SIAC says about this is that it shows that she is engaging, so she has got some understanding of what's going on.
Yeah.
That she has got this concern. Yeah. So SIAC says, I think SIAC puts it. The way SIAC puts it is she's challenging. Sorry, find the reference. Is it 63 models? Yeah, sorry, I may have misunderstood my look. Yeah, so SIAC refers to this as suggesting she has she's not suffering from a sort of cognitive difficulties because she's able to at least grapple.
It's a sort of concrete fact.
Yes, so SIAC says, and then we'll come back to this when I get to my ground 3 in the first episode. This is one of the reasons SIAC says we don't find it credible she didn't understand she was suffering from brain fog.
What they're saying is there's a contradiction in paragraph 36 and 42
Yes.
of Ms. Farr's statement, and elsewhere they talk about the difficulties she had in the uncertainties in her attempts to obtain information from the client.
Yes, so I will deal with.
Between the 17 up to 17 months after the events and so on.
Yes. Yeah, so this is so the relevance of this we'll come back to is because of what SIAC says are contradictions in Ms. Farr's or what appears to be contradictory stances that the appellant is taking, it isn't credible that she did not understand what was happening. I say, well, when we come to that, the error we say in relation to that is how you treat the expert evidence, is the Mbanga-Jakto error.
We'll come on to how SIAC.
Yes.
My question was, do you have any solutions about what said it? So your characterisation of this explanation is that she was, because of her psychological condition, she was unable to act. My words, unable to think about it. How do these factors, this factor in particular,
Unable to take.
do you say?
We don't rely on this as part of that. We say this in terms of my second explanation. I say the second explanation comes into much sharper focus and still operates even if one says she does understand. She has an understanding of what is going on. So even if she does understand, here's rumours about what's happening to British women. These are things that she has got the cognitive ability to understand. That still doesn't explain why she doesn't act. That requires some sort of psychological explanation. And it comes from the reason this comes into such sharp focus is once one accepts SIAC's findings, if one does, you have someone who understands what's going on. So this does show, on SIAC's findings, someone with some understanding of what is happening.
It's not, just so I know, it's not part of your case that another explanation why she didn't act was that she feared she was sent to Iraq.
No, I don't think that was certainly was.
Or it's not part of your case that might fit in with her son, if the fear of being separated from her son.
I don't think I don't think it was put forward in that way, so I can't. No. No, I think that was not how it was put before SIAC. So I think I was dealing with I was just showing you where the second explanation is put, and then the key the point of the submission is these are additional and alternative explanations. You can have someone who understands, but there is some reason that they feel just unable to act. And I showed you the submissions in the skeleton argument. It's the possibility of acting that seems to be beyond her, as distinct from, or in addition to, whether she understands what's going on. And that also appears, again, in Ms. Mitchell's oral submissions below. You have the transcript. Again, you have the beginning, how she opens the case. It's similar to the skeleton, page 8.
You want to go to transcript?
Yes, page 8, supplementary bundle. And at the bottom of the page, you'll see how she opens the case. Line 27, referring to the voice notes respondent's case, she's saying she didn't want to appeal. Submission on F4's behalf, that's also radically incomplete. That's radically incomplete. In this case, as I say, the real question is why she communicated that. And again, at the end of the page, it's both the psychological resources, sorry, and then the top of the next page, to understand or engage, all with the possibility of taking action. And it returns to that again, page 17. You'll see again both explanations. Sorry, the supplementary bundle pagination. So page 13 internal, I think, or 13 of the transcript, 17. And it's around lines 22. The lack of understanding, that's the first explanation, coupled with a psychological inability to engage and contemplate action, a freeze response, an I can't deal response.
Coupled with.
Yes. I mean, one could say you could have both, but you can also have one without the other.
Not suggesting the frozen problem if she did understand, which is the way you're putting it to us.
Well, my submission is that though it does follow, if you can certainly reject one, and in fact, once you've rejected the understanding explanation, this actually becomes much more prominent. But there is no reason why you cannot have a freeze response, unable to act on something you understand. You may understand it, but for whatever reason, you just don't want to have to. For some reason, you cannot take the action that's required. And in terms of the explanation or the evidence to support that, that is Professor Patel's expert report. And again, it's very long, and so I can just flag up some of the key paragraphs. Her report starts at 241 of the supplementary bundle. She sets out the history as it's been relayed to her. She then starts a preliminary and provisional psychological opinion at page 249. And then the key paragraphs are going to be 51 to 56. That's when she starts to deal with the adolescence to young childhood. As I won't take you through that, this sets out essentially the psychological background, the trauma, the conditions in which she finds herself. You see, start of 52. The general conditions, living in the same conditions, abusive relationship, etc. And then towards the end of the paragraph, would have had an adverse psychological impact, referring to the trauma she suffers at the time. And again, she goes back in 55 and 56 to her general psychological position. And then where we get the overwhelm, frozen, etc., is 61 to 65. You see, she's in these extreme conditions, access to adequate nutrition, healthcare, primary concern for survival in such circumstances remain. All concerns and demands not central base humans become peripheral, highly clinical, causal, preoccupied with meeting the needs of her son. And then 62 reports that she seemed overwhelmed, paralysed by fear, deep-seated misapprehension about consequences of lodging an appeal. Indeed, a state of overwhelm is consistent with information available throughout the whole period at our whole. It is the state of being preoccupied, immediate survival, etc. Paragraph 63 explains how people experience traumas, and then describes how avoidance, the psychological notion of avoidance. And you see towards the end, it's the reference which was picked up in the submissions about freezing. Unable to engage in legal proceedings, it's the freezing. That's the notion of avoidance. So that's the second explanation. We say that applies. You can have them together. You can say it doesn't understand and unable to act, and it's all one thing. But you can also clearly have somebody who does understand, as SIAC found, but finds themselves unable to act. And as I submitted, that becomes much more salient once you have SIAC's initial findings, because then you do have someone acting in this obviously contradictory way, wants to come home, has been told they need to appeal, has been made very easy for them. All you've got to do is to write this thing, desperately wants to come home, and yet doesn't do it. And we say the frozen, overwhelmed, unable to act. Not only is it a plausible explanation, it's difficult to think of another one in these circumstances.
Can I just ask,
Yeah.
This expert is expressing these opinions on the basis of material she's examined. That primarily is Ms. Foe's statement.
Yes.
Is that correct?
Yes, I think that's.
Yeah. Yes. She didn't have any dealings in these circumstances with your client.
No, not at all. Yeah, no.
If we go back to 62, Ms. Foe reports that the reference in line seems to make what's the best reference in Ms. Foe as the basis for this expert's opinion?
Of this particular part.
Well, the paralysis, the fear, the being frozen. I may have missed it, but you took us previously to 143 of the supplementary part, which would be the paragraph 40 just a moment ago. But where do you see
I think it's a different one of Ms. Foe's statements, but can I?
That's what would be germane.
Yeah. Well, yes. Can we?
Sorry, I think it's on.
No, but yes. Can we chase that?
Because I hadn't really picked it up so far. I may have missed something.
Yes. No. I haven't taken it. And I will,
Very clearly what the expert was saying, but I was wondering how much to take it.
yeah. I'll find the reference. We'll give you the reference. So that's the second explanation. As I say, our submission is it's difficult to think of what else it could be once you have the apparent set of contradictions, obviously acting contrary to her own interests, other than she has this psychological inability at this stage to act because all of her resources, all of her psychological resources are taken up.
And just also
Yeah.
making sure I'm keeping up.
Yeah.
This second explanation was the only thing I think we put forward to explain delay during the period January 2020 through to July 2021.
Yes, yes. We say it has to apply whatever. Yes, it applies throughout.
But the corollary is it's the only explanation put forward for that period.
Yes, I suppose the first explanation also, if she still doesn't understand,
There are alternatives.
the alternatives, or yes,
So either one or two applies.
Yeah. yes,
You're going to say that the third explanation is you are going to say that also is a factor.
yes. It's a particular factor in the later period.
Well, that's the evidence then from June, or sorry, July 2021.
Yeah. I mean, in fact, we'll see there's some suggestion. I think it was in Ms. Foe at paragraph 40, 41. Yes, my lord is right. So there's some suggestion it applied from the outset. It certainly becomes much clearer in the evidence for the later period.
The only thing about this that particular page is that she doesn't actually put dates on what therefore is describing.
I mean, SIAC understands that to be a description of the initial period.
Mr. Justice Laing asked us if there's any notes, didn't he?
Yes, and I think that the answer was there were notes, but their policy is that they don't, because they're not privileged, they don't disclose. So SIAC's understanding, in fact,
Because they're not privileged.
I think because they're not privileged, they, in order to build people's trust, they have to say, we will under no circumstances disclose them. And I will just chasing the reference for my lord. So that's the third explanation is again set out in Ms. Foer's statement earlier on in the statement that you had. So it's 132. A supplementary bundle. Um, 27. This is she's now saying she's now describing the meetings she has. 132 supplementary bundle. She's now describing, sorry, I should start just over the page. See the heading. She's now describing the meetings, and this may help with my lord's question about what the different things are referring to. She's now talking about the meetings she has, and it's there 27, 28. She expresses the fear of losing her child if she appeals. British government would forcibly take away. She says that is not uncommon. It's not an uncommon fear. There are those rumours in the camp. She then goes on, 31, 32. Again, she's repeating these fears, December 2021. And my lord asked about the 36 to 42, that appears to be, or that's, I think, how psychiatry, I think, is correct, is her prior understanding of her deprivation. So this is, the last 6 paragraphs are describing what the appellant told Ms. Foer in October 2022 about the earlier period. But she's now certainly saying contemporaneously, or this is how Ms. Foer records it, 27, 28, at the meetings in 2021, she is saying that is why she doesn't want to appeal. And I won't take you to it, but Ms. Foer, in her second witness statement, 83 to 89, gives further details about where these sort of rumours come from, why women believe it, even though they tried to dispel them. and again, I won't take you to it, but Professor Patel explains why she finds that clinically plausible, paragraph 66 to 68, 259, clinically plausible. Finally, on the explanations, is we also accept that something else needs to be explained, which is what changes, because if there's no particular evidence as to why things are different in June 2022, the obvious inference will be, well, she just changed her mind, which would not be, a litigant having a change of heart is not going to be, it's very unlikely to be a satisfactory explanation. But here we do have, in some detail, an explanation, or certainly speculation from Ms. Patel and Ms. Foer as to what changed. And again, I'll give for speed, I'll give the court the references. It's Ms. Foer's second statement, 158, a supplementary bundle, 90 to 98. And Professor Patel, 71 to 74, supplementary bundle 260. And essentially, if I could summarise, it's what is critical is the fact that in June 2021, Ms. Foer is able to have repeated meetings. Two, yes, well, that's right. June 2022, reprieve, or she is able personally to have repeated meetings. And she explains this 95 to 96. She's exceptionally able to meet her 4 times in 6 days. And she explains 96 how she is able to take her through the details of what's happened. And essentially what Professor Patel concludes, particularly paragraph 73, is that would be building up trust, which given all the trauma she's gone through, she would not have. And so that's why she says it's entirely plausible that it'll be those repeated meetings that finally means she feels able to take the action, whatever her fears may be.
Sorry, that reference was
260, I think, it should be for Professor Patel.
159.
I'm just trying to find the paragraph.
It is, the key one, my lord, is, so it starts on, it's 71 to 74, starts on 260, but the key one is 73. Highly clinically plausible is the increased trust of the numerous visits, and again, she fits it into the appellant psychology. So that's the 3 explanations and where the evidence is. Can I then come on to our grounds of appeal? And I say, I hope it isn't confused, but I was going to...
Do whatever you want.
Yeah.
Whatever's easier for you.
I'm obliged. And I say, because I'll do grounds 1 and 2, as we've done in the skeleton. They operate on the assumption that SIAC was correct to find that she did understand at the outset that her citizenship had been removed. And we'll turn to how SIAC deals with that. It's 61 to 78, but it says we don't accept that she didn't understand. We don't accept she wasn't certain. So when I then come on to our ground 1, and this is dealing with a second explanation, is I'm assuming I'm wrong on ground 3. SIAC was entitled to find she did understand. We say that's not the end of the matter. It doesn't mean that SIAC can now conclude, well, there's no explanation.
So it's on the supposition that ground 3 is the...
Is this challenging SIAC's finding that she... SIAC finds that she did understand and she was certain that her citizenship was removed. So I'm assuming that was... SIAC was entitled to find that.
For ground 1.
Yes. For
Parking that point to
yes.
ground 3.
Yes. So parking that to ground 3, assume SIAC's correct. That isn't the end of the matter. Because what, and in particular, it's not the end of the matter, because then you have, and I won't repeat my submission, the obvious contradictory, incoherent, someone acting obviously contrary to their best interests, as they themselves identify in her son, someone who desperately wants to come home, told exactly how to appeal, understands what she needs to do, but we say unable to act. And that is, so the obvious question is why? Why did she not act? And I've shown you the submissions and evidence. It's the freezing, overwhelmed, avoidance, just leave it, I don't want to talk about it, don't bring this up. All the focus is on keeping her son alive, keeping what she thinks. And I say Professor Patel provides the psychological explanation for it, the trauma she suffered, etc. And our submission is the error SIAC makes is at no stage does it determine there's no explanation, and no stage it rejects the understanding explanation, but does not then go on to consider the further explanation and the evidence relevant to it. And our submission is that's an error of law. The starting point has to be, what's the explanation for the delay? Here there is an explanation put forward, supported by the evidence, and SIAC is required to decide whether it's made out. And the error, the explanation for the error, and I'll come on to this in ground two, is it may be that once you've concluded that she understands, any explanation will have to be someone is acting irrationally inconsistent. It may be SIAC took the view, as we'll see in ground two, well that's not capable of being an explanation, which we say will be wrong in law. But in any event, for the purpose of ground one, it doesn't matter why SIAC failed as its starting point to determine the explanation for the delay. We say it's an error of law not to do so. And this is again where or this is going back to my beginning, where anxious scrutiny would come in if SIAC has some doubts about whether this factor was properly considered. It would clearly be a factor which might tell in favour of the appellant. And if there's some doubt about whether it's SIAC has shown by its reasoning it was properly taken into account, we say the appeal should be allowed, because that is clearly something SIAC, one would want to be certain that SIAC has considered properly. Is this the explanation for the delay? Finally, in terms of our submissions on ground one, we say if this error has been made, it's clearly a material error. And we don't understand the Secretary of State on this ground to be suggesting otherwise. If SIAC had considered this as a possible explanation for the delay, there is every chance that it would have concluded it was indeed the explanation. This was someone, for whatever psychological reasons, or for the psychological reasons given by Professor Patel, felt unable to act, felt frozen, felt so overwhelmed, felt paralysed. And certainly no one is suggesting it's inevitable SIAC would not have reached that conclusion, or no rational SIAC could have found that to be the explanation. And indeed, as I submitted, it's hard to think of what other explanation there could be given SIAC's finding. And certainly Professor Greenberg, who's the Secretary of State's expert, does not come up with doesn't produce any other plausible explanation, and nor indeed does he criticise, to suggest this explanation is wrong. And again, staying on materiality, had SIAC concluded that the explanation for the delay was crippling psychological pressure, led her to act in these obviously inconsistent, self-sabotaging way, we again say it would have been open to the Commission to find that it was unjust not to extend time in those circumstances. It couldn't be said no rational commission who said, well, it's because of this crippling psychological pressure. She just feels frozen. She just doesn't want to, hasn't got the, in that sense, capacity to act, capacity to take action. It would have been open to SIAC to find, in its discretion, that it was unjust not to extend time. Dealing very briefly with the Secretary of State's response on ground one, the key submission that she makes is paragraphs 42 to 43 of her skeleton, page 51 of the core bundle. And this is the point I trailed earlier. She says, our submissives ignore the fact the burden of proof was on the appellant to demonstrate the existence of special circumstances, place the obligation on the commission, plainly wrong, not supported by authority. There'll be a test in many cases impossible to meet. The reasons why a particular individual fails to appeal on time may be known only to that person. They may not reveal them in the source of an application, etc. We say that's simply a straw man. That isn't our argument. We're not suggesting a person can choose not to reveal any explanation and then say SIAC has erred because it didn't come up with one. In our skeleton, we refer to C12 and the proposition the burden is on the appellant, has to be by way of evidence. If there's no explanation or an explanation unsupported by evidence, generally not appropriate to extend time. That's C12. So we accept all of that. The point is the appellant did put forward an explanation. It's in our skeleton at 47, but it's also, I've shown you where it's put forward below. The extraordinarily difficult circumstances, extreme psychological pressure which gave rise, had meaningful effect to her ability to take rational and coherent action in her and her son's best interest. That's how we put it in the skeleton. And our submission is the problem is SIAC failed to deal with that explanation.
We need to be looking at paragraph 81 of SIAC's decision.
No, this is dealing with, we don't, my lord, I respectfully say, well, I mean, I will deal with it. This will come in on my next ground. This is rejecting the, this is the fear of separation explanation. Explanation 3, ground 2, sorry, apologise. So this is all about the fear of separation, paragraph 81.
But if the frozen explanation, second explanation, is something which applies throughout from January 2020 through to June 2022,
yeah.
What 81 is saying is that didn't stop her from giving the authorisation in July 2021, described as paragraph 31 of SIAC, to take action. She was able to take action and did.
But well, what she does is she gives an oral authorisation to the repatriation and welfare services. So I mean, but my respect, this is simply another element of the contradictory conduct because for some reason, what she obviously.
Forgive me, if that's the way you're putting it, I would expect the expert to take that point on board and deal with it.
Yes, I can check whether she does. I don't know that she does, but I can.
Contradiction of the explanation.
But my lord, I think that's right. I don't think we can shy away from that. In a sense, you do have a situation where you have someone who is.
But if the expert doesn't deal with it, it's a bit difficult to expect the tribunal to deal with it.
Well, SIAC has to decide whether it's a plausible explanation or to reject it. But it certainly had had SIAC dealt with this explanation and rejected it for that reason, I would be in real difficulty. It might well say, well, there wasn't enough in Professor Patel to explain this, or we don't think she could be frozen because she did X. But it's clear she's on SIAC's findings. She is taking steps. Elise says, I'll authorise you to. It is the authorisation for the to authorise to assist her in welfare and repatriation related services.
Because the authorisation at page 70 of the bond, paragraph 31 of SIAC, includes taking any proceedings in UK courts and tribunals concerning the same.
Yeah, but though obviously that's not. She did not understand that to be, and no one understood that to be authorisation to appeal, because otherwise Reprieve would have appealed. So again, I mean, our submission on that, and I say, had SIAC grappled with this and said it's not explained, the experts don't deal with it, etc., then I appreciate I'd be indifferent. But our submission is the earlier one, is you have to at least grapple with the facts and explanation of fraud. And this would just be you do have this contradictory position. There's some reason why she feels launching an appeal to bring legal proceedings in that way. She obviously feels that's beyond her. She cannot take that step. At the same time, she is saying, I'd like to be repatriated, and she does give authorisation for the welfare and repatriation services. That's the contradiction. But our submission is, at the very least, and this maybe comes back to the anxious scrutiny, SIAC had to direct its mind to it and come up with, because I say, especially once you do have the, well, she understands what's going on, it's difficult to think of another explanation. Can I then turn to at least where this part of the judgment comes in, which is the, again, we're now still assuming that SIAC is correct on the understanding points. This is now my ground 2, which is the rejection of the explanation for the delay based on her fear of her son being separated from her. And I flagged up for SIAC where the evidence for that comes from. It's from Ms. Foer's first witness statement, 27-28, 31 to 32, and second statement, 84 to 89. She is now there recounting what the appellant is telling her at the meetings in July 2021, December 2021, and then June 2022, it's gradually dispelled. That is this fear that she has that her child will be taken away from her if she launches an appeal. And again, it may come back to my Lord's question to me about contradictions, and this is something SIAC picks up on. Again, maybe I'll come to it when I get to SIAC's, the relevant bit of SIAC's decision. So SIAC deals with this 79 to 82. She's there dealing with the fear result in the British government taking her child away from her forcibly without her consent. And it deals with that. It carries on paragraph 80. Doesn't accept this is someone without access to legal advice. But of course, at this stage, she is at least having some meetings with the reprieve. Then there's the point that's raised, the fundamental contradiction is, if this is a fear, why is she authorising welfare and repatriation related services? And it's then said, in those circumstances, this is towards the bottom page, it is simply not credible that F4 could, on the one hand, give the repatriation authorisation, on the other, refuse to appeal the deprivation decision because that might involve her being separated from her son. And then SIAC goes on, says that this is a contradiction, therefore, that it says not credible. Then there are only 3 possibilities.
Where are you now?
Bottom of page 87.
Yes.
So
first, this goes incorrect.
Yes. First, she's incorrect. She didn't actually say that. Then it rejects that, or says that's unlikely.
Second,
she's lying.
did not
Or did not genuinely. So in that sense that she didn't genuinely believe it. Pausing there, but what that would suggest is that she's giving a false explanation. There is some real reason she's not appealing, but she's giving this as a false one. It's very difficult to see why that's something that she would do. And certainly there's no evidence from any of the experts that that's a plausible explanation. But in any event, SIAC doesn't reach a conclusion on that she's that's not genuine, that there's really some other reason she's not appealing. And then the third possibility...
Well, they do say line 4 on page 88, that is a possibility. But they say you can't ascribe it to very brain fog.
Yes. No, they say no. I accept. No, they say it's a possibility. No. Sorry, Mark, yes, I accept. They ultimately don't conclude whether it's correct that she was that it wasn't genuine. There was some other reason which she was withholding, and she was giving this as a false explanation. No, I accept. So it doesn't ultimately reach a conclusion on that. And then it says the third possibility.
Well, it wasn't F4's case.
And it wasn't F4's case. So what essentially will come back to is what essentially SIAC is saying is there are three possible explanations, none of which help her. So ultimately it doesn't need to reach a conclusion.
The third possibility is that she genuinely believed that. Don't they accept that?
No, I think what they say is that, they say the third possibility is that she genuinely believed, but they say, even, again, we fully bear in mind her circumstance, bear in mind all she experienced, even so, however, it was plainly entirely unreasonable for F4 to maintain that stance. If the third possibility contains explanation for F4's conduct, it is therefore not a reasonable explanation. And our submission in relation to that is that it's an error of law to say that the fear of forced separation, if it was a genuine explanation, did not need to be considered further because it wouldn't have been reasonable. We say that erroneously conflates a satisfactory explanation with a reasonable explanation. But a satisfactory explanation doesn't require the explanation is based on objectively reasonable conduct.
What does satisfactory mean?
We say potentially compelling or something that might justify.
Yes, well, something which is sufficient to justify.
Yeah, sufficient to make it unjust. Yes. Apologies. Yes, is satisfactory would be sufficient to justify an extension of time, and our submission is. It's an error of law to say that to assume that conduct which is unreasonable, objectively unreasonable, based on belief that objective reasonable person might not hold, is incapable.
But do they actually lay that down as a principle?
I'll come to that moment. No, we say that's the only.
Presumably you seem to accept that on the facts of a particular case, it could be decided that an explanation genuinely held as unreasonable, and that would equate to being unsatisfactory on the merits.
It might.
On the merits of the
It might.
case.
Yes.
Your criticism seems to be that one can't take that approach as a general rule.
What one can't do is, what one can't do, we say, is here the reason SIAC stops at paragraph 82, the reason it decides it doesn't need to go any further on this explanation. Well, there are three reasons it says as to why you might have the position that you do, and it doesn't need to consider any of them because none of them help. And the reason the third one doesn't help is because it's not a reasonable explanation. We say that's, and in fact, maybe I'll make this submission now, if I may, because the Secretary of State doesn't disagree with us on the law. The Secretary of State doesn't say if you reject an explanation because it's not reasonable, if you decide that's not capable of being an explanation that would render it unjust. She doesn't disagree with us on the law that would be an error, but she says SIAC doesn't do that. What she says, and that submission is based on the single sentence on paragraph 81, which is, in those circumstances, simply not credible that F4 could, on the one hand, give the repatriation authorization, on the other, refuse to appeal the deprivations because that might involve her being separated from her son. So what the Secretary of State says is, well, that's the reason. It was rejecting it because it wasn't credible. And she says, well, it's true the Commission went on to consider possible explanations for the contradiction. This is the Secretary of State skeleton, paragraph 51. But she says, those were not in F4's case the operative or material reasons for rejecting her explanation. And our response to that is that it makes precisely the error the Secretary of State accuses us of, which is attempting to read individual words or sentences out of their wider context, because you have to read this sentence with the text that comes after it. And we say if SIAC had concluded it simply wasn't credible, that was the reason she didn't appeal, the text that goes on after that doesn't make sense, we respectfully say, because what it says is there are three possibilities. That is the possibility of why she's given the authorization while at the same time saying she's scared of being separated from her son. If it was the case that that wasn't a genuine fear, there would only be two explanations, the first two. The third one only makes sense, as SIAC says, because it might be genuine. So the structure of the argument is SIAC is, we say that in order to make sense of the judgment, paragraph 81, that sentence, the sentence the Secretary of State relies on, in those circumstances is simply not credible. Before the explanations, that what SIAC is actually saying is that it's not, it has doubts about the plausibility. It's saying it's not plausible she would have done this, but ultimately it doesn't reach a conclusion on it because it decides that any explanation wouldn't help her anyway.
But isn't there an intervening passage we need to look at? In 81 is very long.
Yeah.
This last part of it gives the three possible explanations, more explanations.
Yeah.
And then we looked at line 4, that is the possibility that couldn't be this is not being genuine, but couldn't be ascribed to a competency. But then there's this section after this is not a false case. Given that A, and then 2 lines down, B, the authorization of July 2021, which is what we just looked at in earlier 81 and 31, was so inconsistent with her alleged fear about being to make it likely that her alleged fear was not genuine. So the Commission comes back to the genuineness issue there and then goes on to say it can't be satisfactorily explained by reference to mental state, i.e. the fog point again, the motivation must lie, but to ask what it might be would be to embark on speculation.
With all respect, and
Lack of genuineness seems to be left on the table.
it is. I mean,
Before you get to the objective issue in 82.
But we accept that our position, our submission is that all three possibilities are left on the table because, and SIAC concludes that it doesn't ultimately need to reach a conclusion. That's, we say, the only way this makes sense because none of them would help her. So we accept that what SIAC has said is we have doubts about the genuineness, but we say this is the only way that the judgment coheres, is to say we have doubts about it, but there are only three explanations and none of them would help us. So we absolutely accept the genuineness was left, the possibility that it wasn't genuine was left open, as was the possibility it was genuine. The problem was SIAC never reaches a conclusion because it thinks all three don't help her. And the error of law is to why it doesn't think that the third would help her. So it doesn't need to go further than say it's unreasonable. So my Lord, I entirely accept it does recognise it's not genuine as a possibility. There are three possibilities, but it wouldn't help her.
Surely, you might be isn't simply not credible a finding?
Well, again, we say it wouldn't make sense if one then goes on to there are only three possibilities, because then there'll be two possibilities. If it's simply not credible, there are two possibilities. Either she never said it to Ms. Fowler, or it just wasn't yet. She really wasn't scared of separation. So we say the three possibilities, and again, this may take me back to anxious scrutiny, if this is at the very least ambiguous, but we say that the only way it makes sense is to say, and I take my Lord's point, if read in isolation, you say, well, that's a finding. But if you read it with the rest of it, what it appears to be is a doubt. Certainly their initial view is it's not plausible, but they don't reach a finding because otherwise they wouldn't have the third explanation.
Unless the third explanation comes along as an alternative explanation, even if we would succeed nevertheless.
I mean, our submission is that I certainly cannot safely read the judgment in that way, would be our submission. It reads as if what they have said is, we absolutely accept they express doubts about the genuineness, but that reading it together, what they have said is essentially none of these would help. Otherwise, they've simply said so. It's not genuine.
Well, aren't they saying candidates will fail to displace our view that this isn't credible?
I don't see how the 82 could be displace our view. It's not credible. It's if it's genuine. It would be unreal.
It's quite strange. I'm not quite sure what 82 is doing there because in 81 they say you mustn't speculate. Isn't 82 going on to speculate?
Well, I think 81 is saying you shouldn't speculate if you conclude that she's lying, or that it's not, that she's been telling Ms. Foer this is the reason it's not. She's then saying, well, we have no idea why someone would be doing that, and so that's how we read that part of it. And there are two other reasons why we say this for our submission as to why we do say it is SIAC's view, or SIAC does take a view about the reasonableness of the explanation, does think that is a requirement. And the first reason for that as well, we say if you read it all together, we say that's what it must mean, or it appears to mean. The other is that the word reasonableness is picked up again by SIAC when it sets out its conclusions. If you have a couple of pages further on, page 89, paragraph 85, SIAC has dealt with explanation and then says, well, are there other relevant factors? Start of 85. Can't make a decision about merits. It remains the case that as Mitchell submitted, refusing to extend time leaves no prospects of her keeping. Extremely uncertain future, accepts all of this. The fact remains, however, that SIAC has failed to show a reasonable explanation for the extreme delay we have described. So again, it does appear and this is undoubtedly the operative part of its decision. This is where it's setting out at the end. Well, you have come up with some other, you said, look at the impacts on her. However, they'll show a reasonable explanation. We say it's not a coincidence, picking up on the word used a few paragraphs earlier, which in our submission suggests the error of law that we're ascribing to SIAC, i.e. deciding that if an explanation isn't reasonable, you can stop there. And SIAC also, when it refused permission to appeal, what SIAC didn't say in relation to this ground is the submission the Secretary of State now makes is, well, none of this was material. We already decided this wasn't credible. You'll see how SIAC deals with this at page 95 of the bundle. It's quite a detailed refusal of permission to appeal. You see, this is the ground here, error of law regarding subjective fear. 95 of the core bundle. You see, this is where this ground is dealt with by SIAC. It summarises that it's essentially the submission I'm now making. Subjective fear of separation of a child was not capable of providing a reasonable explanation. And then it says, SIAC didn't lay down a general principle of subjective fear is incapable, rather taking into account F4's particular circumstance included authorisation where such a fear would not be reasonable. And on respect position, that is precisely the error we're attributing to SIAC. SIAC doesn't say, no, you've completely misunderstood, that wasn't the basis of our decision. What it repeats is, on her particular circumstances, we concluded such a fear would not be reasonable. And all respects, it doesn't matter for our purposes whether SIAC's laying down a general principle or not. The question is, why did it stop in this case? And the reason it stopped in this case, to consider that explanation, is because that one it thought would not be a reasonable fear. Such a fear would not be reasonable.
Even if you're right about that, what do you say about what's in paragraph 23?
Coming on to that next. So that's my submissions on the error. Then that goes to materiality. Sorry. Yeah. I think it's very different when you submit it's not capable of being relevant at that stage. If you ultimately, what is just and unjust is a very broad discretion that SIAC has. It seems to me at least one could say you give more weight to an explanation of someone acting reasonably than someone not. So I wouldn't say as a proposition of law, it's legally irrelevant, but we do put it the other way. It will all depend on the explanation for the unreasonable conduct. So if there is a compelling psychological explanation here, the trauma, the fear, you see it's Professor Patel, the enormous fear she has of her son being ripped from her, even if that's an unreasonable belief, living in the camp in these sort of circumstances, that might well carry significant weight in terms of injustice. But I don't think I'm able to say as a matter of law, SIAC would not be allowed to consider that. But as I say, here we don't get anywhere near there because it simply stops. Yeah. In terms of the other explanation, so this was my Lord's question about the other issue that SIAC raised. So that's now materiality of the error. Or this is what it would go to and say, well, this isn't material because it doesn't explain the whole period of the delay. Three submissions in response to that. First, I've shown you SIAC's conclusion, paragraph 88, which relates to the entirety of the case. At this stage, they simply say, not a reasonable explanation. They're not there talking about separation from her child. Two, this may be, and this links to ground one, may explain why SIAC, once it concluded she understood, felt like it was able to stop. Because it then says, well, you then have all these contradictions, but SIAC feels it doesn't need to go further than that because she's understood and anything else will be unreasonable by definition. She's both authorising repatriation, not authorising an appeal, etc., etc. And thirdly, we've also seen, and this is some in fact SIAC holds against her, which I'll come to shortly, that she's saying from the outset that she's afraid her child will be taken from her if she took steps to appeal. That's paragraph 41 of Ms. Foe, and that's under the heading of, she's there dealing with that. So we do say infects the whole period. Can I turn then to ground three?
Can I just go back to your submission on page 95 of the core bundle?
Yeah.
The refusal of PTA by the Commission.
Yeah.
You took us to paragraph 22, and the tribunal said they weren't applying a general principle. And then you criticised the last sentence of taking into account F4 particular circumstances. Pausing there for a moment, if the Commission in a particular case does look at circumstances, then it would appear that they're not applying a general principle.
Yeah, the question is, in this particular case, did it stop?
Well, the question then is whether they did an error in the way they looked at the particular circumstances.
Well, no, I mean, our submission is, again, going back to the structure of the judgment, what they don't say, and this maybe is my lady's point, is if they went on and said, well, in this particular case, we find that the unreasonable delay would not allow for an extension of time for these reasons. But that certainly doesn't appear to be what it's doing. It simply seems, once it's decided, it's not saying in this case we would find it for all these reasons, because then one would have to go into why do you have the explanation in this case?
It's in brackets, in the last sentence 22. Those circumstances include the authorisation by F4 to repatriate to communicate. That's going back to paragraph 81. And the authorisation in July 2021, which she then gave.
But that's...
They're relying upon that as affecting their judgment of the reasonableness of the stance when they come to this third matter.
But what they do, so they're not. We say, well, we'll say they're not entitled to stop at this would be unreasonable. what you have to say is you would have to go on to consider whether, if you have this unreasonable, first you would have to certainly have to consider why you're taking this unreasonable stance, because
Well, that's what they do in 81 and 82 as best they can.
what aspects is no, what they're doing in 81 to 82, explaining why they say it's an unreasonable stance, not why she is taking a stance of that kind. And that's why you would need to go back to the psychological explanation, at least why she is someone who is acting in what does appear to be contradictory ways. So our submission is they certainly don't get to a stage where they say, we're now deciding whether it will be unjust given all of our findings. They simply stop at, it's unreasonable, we don't need to go any further. That's why we say, well, that's why our submission is they made that error of law.
And just so I'm clear, if I may, why do you say all that isn't renders irrelevant by paragraph 23?
Because one, the reasonable explanation is applied in the conclusion that goes throughout paragraph 88. Two, it certainly may well explain why SIAC stops where it does. This links to ground one on understanding. But third, SIAC certainly gave weight to the fact that she was expressing this concern throughout, or certainly at the outset. So back in January, this was an anxiety playing on her mind. And there's certainly obviously no suggestion it's gone away, because she then repeats it when she sees Ms. Foer. Can I turn then to our ground three, which is how SIAC deals with the I didn't understand, or the appellant did not understand, she wasn't certain that her citizenship had been removed. Now that we accept that SIAC considered it and it found that was not credible. And the error, we say, is the Mabango-Jacto error, which is that if you have expert evidence that's relevant to credibility of an account, it's an error of law to reach a view, even a preliminary view on credibility, and then only then turn to the expert evidence and see if it displaces that preliminary view. And I can take you relatively quickly to it, maybe able to turn them up, Mabanga and Jacto. You have Mabanga in tab 1. The authorities bundle. You'll see from the head note what the case is about. It's an asylum claim. Appellant claims he's captured by Rwanda-backed rebels in the DRC and tortured to extract information relevant to the conflict with the militia group of which the appellant, was a member. Paragraph 6, the Secretary of State expresses, it says, comprehensive disbelief of the history given to him by the appellant. Doesn't think he was detained, doesn't think he was tortured, etc. And the adjudicator, paragraph 15, also finds the account to be, I think in her words, entirely or wholly non-credible. And you'll see the reason she gives at paragraph 15. Each bit of the account goes through it detail by detail, inherently implausible, not credible. E, account of his second escape was wholly not credible. I, doesn't accept it's credible, not credible that he was tortured, etc. The problem was, as the Court of Appeal finds it, that it's only after expressing those views. You see paragraph 16, this is from Mr. Justice Wilson, as he then was, Justice Wilson, as he then was, as judgment. It's at this point, and only at this point of determination, that she turns to Dr. Norman's report. Now, Dr. Norman has provided medical evidence that supports the account of torture. You have the reference to her, Dr. Norman's reports 11 to 13. And what the adjudicator says, the medical evidence does not assist the appellant. It explains why. I conclude that the medical evidence does not assist in establishing the appellant's case, and the doubts I've expressed on the credibility of the fundamental claim have not been resolved. And just picking up on that, you'll notice the word doesn't assist the appellant, and also refers to the doubts she's expressed, because those precise words also then appear, we'll see in SIAC's reasoning in this case. It talks about Professor Patel's evidence not assisting the appellant. The Court of Appeal then explains why that's an error of law. Paragraph 24 to 25, you'll see Mr. Justice Wilson, particularly 24, and then the first 3 lines of 25. It seems to be axiomatic the fact finder must not reach his or her conclusion before surveying all the evidence relevant thereto. Agrees with Mr. Town for the Secretary of State, you don't reserve the fact-finding functions. What, however, they can offer, this is an expert report, is a factual context, this is midway through the paragraph, factual context in which it may be necessary for the fact finder to survey the allegations placed before him, and such context may prove a crucial aid to the decision whether or not to accept the truth of them. What the fact finder does at his peril is to reach a conclusion by reference only to the appellant's evidence, and then, if it be negative, to ask whether the conclusion should be shifted by the expert evidence, and then accept what's said in HE, where the report of this an expert report is specifically relied on as a factor relevant to credibility. The adjudicator should deal with it as an integral part of the findings of credibility rather than just an add-on, which does not undermine the conclusions. In my view, such was the first error of law into which the adjudicator fell. She addressed the evidence only after articulating conclusions were not credible. And Lord Justice Buxton, you'll see, also agrees and gives a concurring view 29 to 30. He explains how the appellate court should be careful not to interfere and only interfere with errors of law. But here, paragraph 30, it does meet the criterion error of law. Adjudicator's failing was that she artificially separated the medical evidence from the rest of the evidence and reached conclusions as to credibility without reference to that medical evidence, and then, no doubt, inevitably on that premise, found the medical evidence was of no assistance to her. That was a structural failing, not just an error of application, and demonstrated the error identified in HE. And Jacto you have in the next tab. This is a case about how an accident at work had occurred. Mr. Hall, who's the respondent at this stage, injures himself at work. He gives evidence, paragraph 8 to 13. The appellant, who's the company Jacto Transport, calls 4 witnesses who all arrived after the accident occurred. This is paragraph 14, including one, Mr. Ramsden, who arrives quite a bit later. You then have an expert report from Mr. Glenn, paragraph 20 to 24. And then paragraph 26, in Lady Justice Smith's judgment, you see, judge found Mr. Ramsden to be a truthful and convincing witness. He's one of the Jacto, one of the company's witnesses, found the appellant's other 3 witnesses to be unsatisfactory, explains his reasons. He says he's inclined to believe, he hears the respondent being crossed out, inclined to believe him, so this is the individual injured at work. And on the basis of that assessment of the lay witness, and without making any reference to the experts, he made some preliminary findings of fact, which are there set out, then turns to Mr. Glenn's evidence and concludes they don't assist. And again, you see paragraph 28 towards the end, it's the same error of law. Mr. Murphy, who's for the appellant here, for Jacto Transport, towards the end of paragraph 28, Mr. Murphy's complaint was the judge had considered the respondent's credibility in isolation from the expert evidence rather than the light of it. In that respect, in my view, Mr. Murphy's submission has considerable force, reached preliminary or provisional conclusions as was happened before considering the evidence of Mr. Glenn. Then, when he did consider it, did so only to ascertain whether it caused him to change his mind. In my judgment, that was an error of approach. whereas here the expert evidence was relevant to the way in which the accident could or might have happened, it was incumbent upon the judge to consider it at the time when he was reaching the conclusion on the credibility of the witnesses, and then set out Mabanga and concludes, same thing, same error, 31. The judge should not have found the facts, even provisionally, without considering the evidence of Mr. Glenn. And our submission is that SIAC makes precisely the same error. It's the Mabanga-Jacto error, which is, it first considers whether the appellant's account, as recorded by Ms. Foy, is credible, i.e. whether it's credible that she didn't understand her citizenship had been removed. It reaches a preliminary view at the very least, doubting her credibility, and then it considers whether the expert report would, quote, assist the appellant, and concludes that it wouldn't. And we say that is the Jacto-Mabanga error, and you can see it if you turn to SIAC's reasoning on this. It's paragraph 61 to 65, page 80 of the full bundle. So my lords, may recall paragraph 61. We're now talking about Ms. Foer's first witness statement, paragraphs 36 to 42. And she's explaining what the appellant said to her in October 2022 as the explanation. So this is you recall those 6 paragraphs, I wasn't certain, I didn't understand. And SIAC sets out a series of reasons for doubting the credibility of that evidence. It's plainly in her interest to give an explanation, one therefore needs to read with caution. There's then the contradictions. And this is the point that I was asked about earlier about, she's heard about rumours. Well, that shows she at least has some understanding of matters. There's then this paragraph 41, so SIAC, this is the point I made earlier. She is at this stage concerned about her son being separated from her. SIAC concludes that must relate to the earlier period. She says, well, that's inconsistent. That's then a contradiction if that's what she might fear, that she's still asking for assistance indirectly from Bernberg's, or she's not communicating that to her family and telling them that she still wants to return home. So that's all the reasons for doubting. And then we say in language very similar to Mabanga, you then turn to Professor Patel and say, we do not find the appellant can derive material assistance from the reports of Professor Patel. We say that's the error. You need to consider Professor Patel's evidence in relation to this. And it might actually help if I the key paragraph in Professor Patel is paragraph 57, which is at page, if you flick to that, I'll possibly around to 256. This is her conclusion, and this is dealing with those paragraphs of Ms. Foer's statement, and in particular deals with the letter from Reprieve, the one that the court found so clear. She reads that and she explains why, despite that, she thinks it is highly clinically plausible that she didn't understand. Yeah, that's the way she phrases it. I think partly because she hasn't spoken to her, so that's how she phrases it. So that's her. So she is giving evidence in support of the credibility. What you have an account that on one level might be regarded as implausible. You have this very clear letter from Reprieve. How is it that the explanation she didn't understand? This is Professor Patel saying, here is my clinical view as to why that is plausible. One could have that letter and still not, given all the background, understand. The error of law we say, this is precisely as in Mabanga, as in Jacto, expert evidence that will support the credibility of an account. But what SIAC does, it reaches the conclusion, it expresses all these doubts about the credibility of the account, and then it says the evidence of Professor Patel doesn't assist.
Given the SIAC's conclusion about Professor Patel's follows paragraph 66 onwards, and summarise dismissing commission of view, how can that evidence have any impact on credibility, even if you're right?
Can I come on to that, my lord? So yeah, because we say that would be relevant to a materiality argument. So I might say, well, it wouldn't matter if they had considered Professor Patel because of what they say later on about her. So can I come on to that in a moment?
Yes.
But can I make one, or I suppose maybe this is one of the answers to that, is that we say that in this case the error is worse than the Mabanga Jacto error, because when SIAC then explains why Professor Patel's evidence doesn't assist, one of the key reasons it says her evidence doesn't assist is the conclusion SIAC has already reached about the credibility of the account. So if one looks now at the reasons for rejecting, so my lord's question to me, it notes that it notes 66, so it doesn't assist. It first notes that it's a preliminary and provisional conclusion, but then also notes, as my lady says, it's still put in terms of clinical plausibility, albeit of a high order, highly clinically plausible. But then says this: those findings have proposed that everything F4 is recorded as saying to Ms. Furr is not only more likely than not to be an accurate statement of what F4 said to Ms. Furr, but also an account by F4 that is more likely than not to be genuine. We already explained why there is good reason to doubt the genuineness. Now, we say that's entirely circular, but Professor...
And if they put this section of the judgment earlier on for dealing with her evidence, you could run the same argument. I mean, you can't express all your reasoning in a judgment simultaneously.
Well, except that her evidence...
Has the Commission reached a conclusive view on credibility before they came to assess Professor Patel? They raised the doubts. Had they signed off on it?
Well, but that's exactly the same as in the Mabanga and Jocton. That's why I said even a preliminary, you shouldn't reach a preliminary view. And this precisely illustrates it, because this is the error, or compounds the error, because part of the reason they're rejecting, they're saying it doesn't assist because we've already doubted the genuineness. But of course, her evidence, paragraph 57, was precisely trying to explain why that might seem unlikely, but it was a genuine account. So if you've rejected her evidence because you've already reached that conclusion, so that's one, circular, but two, that is precisely the error, and it compounds it.
The second sentence of paragraph 67 does not stand alone, does it? Because having referred back to the doubts about the genuineness of the account, good reason to doubt, maybe the way to put it, because that's what the law just made. The negative, quite apart from that, it makes a series of other.
Yes, and I'll come on to those. But the first one, certainly the first one it comes to, we say error of law and it's clearly circular to say it's an account that tells you why it's plausible. We're rejecting it because they must have reached a preliminary view, because they're then rejecting it because of the preliminary view they've reached, the doubts that they have. And I say it's the same in Mabanga. The adjudicator also talks about hasn't dispelled my doubt. So when one talks about doubts, that is sufficient there to be regarded as a confirmed view. You then have the Musfoa. Well, it was passed on, but again, that goes to the. It isn't suggested there. Sorry, perhaps I'll take a step back. The rest of the criticisms, and really, it's in fact two criticisms. There's one is the Musfoa point. It's not really a criticism of Professor Patel. It's just an observation about where the information comes from. The only other criticism that's made of her appears in paragraphs 68 to 71, and that is to do with the way you see at the top of 68, we accept the criticism by Professor Greenberg, Professor Patel's account of F4's early life and the inference Pretteville draws from with regard to F4's are based to an impermissible extent on what Professor Patel heard from F4's mother. Professor Patel then puts in further evidence in response and explains she wasn't able to get any more information. And SIAC then says at the end of 71, the limitations that this imposed on Professor Patel's ability to address the complexity of relationship between F4 and her mother should, however, have been made plain in the original report. That criticism of her, and she then wrote a further report and said, well, look, this would not have changed, even if I had had a more positive account of what she did in England between age 4 and 17, it wouldn't have changed my view. So the professor put that evidence in addition. What we say about this is that if this is to be said to be an answer to the case, that can only be because it's not a material error. One would have to say SIAC could not have placed any weight, or SIAC did not and could not properly place any weight at all on Professor Patel's report. Therefore, this error is not material because we have these, no weight could be put on it in any event, even if we did consider both of them at the same time. But that isn't what SIAC says, and it couldn't possibly have said so, but certainly it doesn't say so. And this comes into, we were refused permission to appeal on a fourth ground, which was, we raised concerns about the way in which SIAC criticised Professor Patel, and my lady, in refusing permission on that ground, said that SIAC wasn't even arguably challenging Professor Patel's integrity and competence. We suggested they'd unfairly challenged her integrity and competence. My lady refused permission on the basis it wasn't arguable that SIAC were challenging her integrity and competence. And of course we accept, we can't pursue that criticism of SIAC, but what that does mean for ground 3 is that it can't possibly be said that SIAC did conclude that Professor Patel's evidence should be given no weight at all. It has some concerns about it.
Ground 4, you refused permission.
Yeah.
I'm reading from ground 4. SIAC early rejected the evidence of Professor Patel's relation to ethical state down in 2020. So you understood SIAC's decision to amount to a rejection about you refused permission to answer. At the moment, I'm just not really understanding. If the position is that SIAC rejected Professor Patel's evidence about ethical state of mind and with no challenge that, I just don't understand where this Nabanga point goes.
I suppose our submission is that, well, first we refused permission on the basis, our submission had been that we understood that they had challenged her integrity and competence, and we refused permission on the basis that it was found that that wasn't the conclusion. And I suppose I have to say, in the light of the refusal of permission, we do say that it is not a wholesale rejection of Professor Patel's evidence that would be required to defeat ground 3, because what one would have to say is that it wouldn't matter if they considered Professor Patel's evidence along with her explanation, because no weight could be put to it. So I suppose I said ground 4 is maybe put different to how what one would need for a no material error defence to operate. So we say that isn't SIAC's conclusion. One can't say the error didn't matter. It had reasons why it certainly gave less weight to Professor Patel. We accept that. Maybe that would have been a better way to put it.
Well, if we go to the grounds of appeal, please, for my latest decision, page 16, we've gone to competence control and integrity. First of all, the first sentence of ground 4 limitations on her sources, which goes back to the way in which material was collected by the firm and described
Yeah.
by the conditions. And at any point made there, that was something that she factored in. But it was understood that her evidence was being rejected, in part for that reason.
And maybe this is now slightly different. I wrote now saying we probably should have framed ground 4 differently. It's giving less weight to her evidence would be in a better way to say it. 'Cause in fact, at no stage do they actually reject her evidence. What they say is it doesn't assist. It doesn't assist her. Well, we respect saying no, not given the conclusions you've reached. You've reached conclusions expressing doubts, and you then say it doesn't assist.
What I'm trying to understand, with the court in the Laing that said that the tribunal, the judge there, fell into error because it didn't factor into their findings of credibility. The report provided no assistance.
Well, it doesn't assist, but that's because you've already reached the conclusion. And I say one of the reasons it doesn't provide assistance. I mean, it was exactly the same language the adjudicator used. She found that the report on torture did not provide assistance to.
It was surprising because, of course, it was a report on the signs of the injuries.
Correct, but
it was objective evidence.
no, I accept that. This is obviously a different type of report, but it is nonetheless expert evidence on credibility, and it's found, we say, not to assist. And I don't entirely accept the way in which that's worded may have been.
There's a difference between expert evidence which is found not to assist because you've already reached a view about credibility, and expert evidence which is found not to assist because it's got lots of flaws in it.
I'd say then I come back to the first reason for saying why it doesn't assist is the view you've already taken on genuineness.
Well, now it's that clock gone. That clock is about 4 minutes slow, so we're well past.
Yeah.
1 o'clock. So you're advised now. We'll resume. We'll go with that clock. We'll resume at 2:05 by that clock. How are you doing?
I think I have finished. I think there was just the I think we were going to provide the references, but I don't. But should we do them? Can I provide those off?
Yes. We'll hear your final observation.
Yeah.
Till 2:05.
Yeah.
Thank you very much.